Hello and welcome to Spardha Lines, your one-stop destination for the civil services preparation, UPSC, KPSC and other relevant examinations. Today, before we start with our analysis for the day, we have two important announcements. The first is with respect to the magazine. We are happy to launch the Spardha Lines Special Issue Part 1, which will cover all the important topics and issues that are important from your KAS examination point of view, CTI, Group C, PDO, FDA and other state exams, and we will cover under the first edition topics that are relevant for your examination preparation from November 2022 up until April 2023. This will be released today and it will be comprehensive with about 40 pages. So the first edition will be released today and the subsequent edition from May up until December will be released in the month of December. The second important announcement is with respect to the test series. How do you understand what type of questions can be anticipated in the examinations? What you have to do is take up the test series. What we are bringing to you is the test series, which will be an all Karnataka GS test series for CTI and Group C exams on 22nd 10/2023 at 10 AM. All Karnataka communication paper test series for CTI and Group C exams, which will again be on 22nd at 2 PM. Then we will have the weekly current affairs test series on 18th as well as on 25th at 10 AM. This is very important so that you understand how this exam works. So please do take this test series and understand how this entire test series works so that it is important for your examination point of view. Let's get started and look into the first article. The first article speaks about the same-sex marriage. What we have is the Supreme Court, which delivered a landmark judgment with respect to the same-sex marriage. So what we will try and understand is what is the same-sex marriage, what is the petition all about, what have been the arguments made by the petitioners, what are the respondents' arguments, that is the Government of India's arguments, and we will also look at what is the 3:2 judgment and the way forward with respect to the same-sex marriage. First up, we have to understand what is the same-sex marriage. Same-sex marriage is a concept wherein people from the same gender and sex get married to each other. This is where the concept of LGBTQ comes into picture. What is this LGBTQ? Basically, L stands for lesbian, G stands for gays, B stands for bisexual, T stands for transgenders and Q stands for queer. What has the Supreme Court said with respect to the same-sex marriage? A constitution bench of the Supreme Court held that only the legislature can recognize or regulate the same-sex marriage. The bench reasoned that since there was no fundamental or unqualified right to marry, the courts cannot intervene, said the Supreme Court of India. So in a 3:2 judgment, the Supreme Court went on to say it is only the Parliament which should be able to make the laws and the Supreme Court need not have to look into it because that's the domain of the legislature. It is only they who have to come up with the law, said the Supreme Court of India. It is in this particular backdrop we have to understand what was the petition. What was asked before the Supreme Court of India? Two gay couples wanted to get married, but they do not have any provisions under the Hindu Marriage Act or under any other personal laws. So what do? They come up and go before the Supreme Court of India and plead before the Supreme Court of India, dear Supreme Court of India, look into this particular issue. We were not able to get married under any of the personal laws, so why not consider our petition that we get married under the Special Marriage Act. So what was the petition all about? These gay couples said that they want to get married under the Special Marriage Act. Why? That is because when you look into the provisions right now, the provisions of the Hindu Marriage Act or the Foreign Marriage Act or for example other personal laws does not take into picture the rights of the LGBTQ community. It does not take the rights of the same-sex marriage, and as a result the crux of the matter revolves around 20 petitions filed by the same-sex couple, transgender individuals, LGBTQI activities. These petitions collectively challenge the provisions of the Special Marriage Act, Hindu Marriage Act and the Foreign Marriage Act. So they basically said since these laws do not recognize the same-sex marriage, in case people from the same gender and sex would want to get married, they should be able to get married under the Special Marriage Act, said this particular petition. So the first question right now is, what is the Special Marriage Act? The Special Marriage Act was drafted back in the year 1954. So we have the Special Marriage Act of 1954. what is the importance or the significance of the Special Marriage Act? When we speak about the Special Marriage Act, what was the intent of the legislature? When we look at the Hindu Marriage Act, we have the Hindu Marriage Act. Let's say, for example, the couple, a man and a woman, want to get married. They are Hindus and the practitioners of the Hindu customs and the traditions. So they want to get married. They will get married under the Hindu Marriage Act. So they will get registered under the Hindu Marriage Act. Subsequently, in case there is a Muslim couple, both man and women happen to be followers of Islam, so they are Muslims by nature, so they would get married under the Muslim personal laws as well. But when it comes to the gay or the lesbian or any other transgenders, in case they want to get married, they did not have any laws, so they were asking to get married under the Special Marriage Act. But the Special Marriage Act did not have any provisions for the intersex couple. So we have heterosexual couples who would be able to get married under the Hindu Marriage Act as well as the personal laws. But what about the same-sex marriage? What about the homosexuals? They did not have any provision whatsoever. So let's bring them under the Special Marriage Act. So this Special Marriage Act was brought into picture primarily because if people from different communities, let's say for example, there is a Hindu who wants to get married to a Muslim. It can be of any gender. That is, if there is a Muslim who wants to get married to a Hindu, or there is a Hindu who wants to get married to a Christian, and all religions, irrespective of the religion, if there are couple who want to get married, they should be identified under a law, and that law is the Special Marriage Act. So in Special Marriage Act, what we have is people, heterosexual couples who would be able to get married from a person who is from a different community. When it comes to Hindu Marriage Act, it is only Hindus who will get married. When it comes to the Muslim personal laws, it is only Muslims who will get married. So how about people who would want to get married to a person from a different religion in order to identify, in order to give them authenticity to their marriage? What we had was a Special Marriage Act. So in case there are people, heterosexual couples who are from different religion, they want to get married, that is what we have in the form of a Special Marriage Act. The Special Marriage Act also has certain provisions as well. What are these provisions? The first major provision is with respect to the age. When we consider the age of an individual, let's say for example a woman. A woman should be above 18 years of age. A man should be above 21 years of age. The same will also fall into the criteria of the Special Marriage Act. So in case couple want to get married, this criteria should be met. First example. The second is with respect to, at the time of the marriage, they should not have had a valid marriage, which means to say, even if they had a valid marriage, they should have divorced. So polygamy is not entertained under the Special Marriage Act. Second condition. Third condition is they should be able to give the consent. Consent of what? That if a person is going to get married, it can be a man or a woman, they should have a sound mind. They should be able to take a decision. They should be able to take decision that this particular marriage is according to their own free will. It is voluntary and it is not being forced. So the Special Marriage Act recognizes three major compartments. One is with respect to the age. Second is with respect to preventing the polygamy. The third is with respect to the soundness of the mind. So the Special Marriage Act was with respect to the heterosexual couples. So a petition was filed before the Supreme Court of India that, dear Supreme Court of India, while the Special Marriage Act speaks about couples getting married, it is with respect to heterosexual couples. Why not introduce, reinterpret the Special Marriage Act in such a way that this entire canvas of the Special Marriage Act also includes the homosexual couples? So this was the petition that was filed before the Supreme Court of India. They said that we are the gay couple, we are the lesbian couple, we are the transgenders, we are the bisexual, so on and so forth. Recognize our homosexual marriage under the Special Marriage Act. So the Supreme Court first had a question. What was the question? Can we accept this marriage? Because the Special Marriage Act, as a prima facie, when you look into it, it only speaks about heterosexual couples. So what did the Supreme Court say? The Supreme Court said, we will not look into the Special Marriage Act as a whole, but what we will look at is a concept of a civil union. So what is a civil union? It is a legal agreement between individuals that provides them with some of the rights and benefits of a marriage, such as inheritance rights, tax benefits and access to the healthcare. So we will not look at marriage as a concept. Instead, we will only look at the civil union concept. Now the question is, what is the difference between civil union and a marriage? When it comes to the marriage, what exactly happens? It is recognized world over by all countries as well as states. For example, a marriage as a concept can be recognized by a country, let's say United States of America or United Kingdom or Saudi Arabia or Japan. So world over, countries have recognized the concept of marriage, but this concept of civilian union is only with respect to a certain countries itself. For example, it might be present in United States of America. Even within United States of America, it can be present only within few states as well. That is one example. Others, it can be present in Sweden, it can be present in Norway, it can be present in Brazil as well as Chile. But is it recognized world over? No, it is not recognized world over. It is not recognized in some of the states as well. So the first marriage and the civil union is recognized only in few countries and states, but when it comes to the concept of marriage, it is something divine and has to be accepted by and is accepted by most of the countries and all countries of the world. First major difference. Second major difference is when it comes to this concept of marriage, it has the authenticity and the stamp of the religion. It has the customs, prevalence, values, traditions all come into the picture. So when we speak about the concept of marriage, it is accepted by the religion, but when it comes to the concept of civil union, it is more of agreement in nature and may not be acceptable by the religion. When a concept of marriage, it is a concept of divinity, it is a concept of the nature, so it has been accepted by all religions, but a concept of civil union is not acceptable to the religions. So the major difference is, if there is a concept of civil union, if there are homosexual couples who would want to get married, what are the rights that can be given to them, what are the legal mandates that would be given, is the restricted loop of the civil union. So the Supreme Court said that we're not going to look into the entire premise of the marriage, but we're going to look into what is the concept of civil union, as to what are the rights that would be given between the partners is what will be looked into by the Supreme Court, said the Supreme Court of India. And as a result, we have the respondent, which happens to be the government of India, which immediately enters into the picture. Now what we have to look into is the arguments that have been made by the petitioners. So what are the arguments that have been made by the petitioners? The petitioners say that whenever we are going before the Supreme Court of India, we have arguments to substantiate that this is a violation of Article 14. So they go on to say that there are a couple of articles which get violated. Article 14 is getting violated, Article 15 is getting violated, Article 19 is getting violated, Article 21 of the Indian Constitution is getting violated. Why? That is because when you have the rights given to the heterosexual couples who would be able to get married and who would be able to lead a dignified life, which is an aspect of right to Article 21, if that is guaranteed under Article 21, why not give the same to us? If you're not giving the same marriage concept to us, it ultimately is violating Article 14 of the Indian Constitution. It is a violation of Article 14, right to equality irrespective of the gender. That is what speaks about Article 15. So sex is not a matter of discrimination. There should be no discrimination on the basis of sex. So only if you are creating the differences on the basis of sex, it is once again violation of Article 15. So equality is getting violated. We would not be able to lead a dignified life. Article 21 is getting violated. You are discriminating us on the basis of sex. Article 15 is getting violated, and we are not able to speak openly about our relationship. So freedom of speech and expression is getting violated. So this is where they're bringing cases after cases to substantiate and validate their claim. So the first important judgment they bring into picture is the Nalsa versus the Union of India. What is this Nalsa versus Union of India? The court upheld the right of the transgender persons to decide their gender. In this specific case, the Supreme Court went on to say, irrespective of the gender, if a person wants to identify himself as a man, he would be able to do so. If it is a woman, he would be able to do so. If it is a transgender, the transgender would be able to identify as a third gender. So the state governments and the central government should be able to give a third column where a person who wants to identify himself as a transgender would be able to do so, said Nalsa versus the Union of India. Then we have Shafin Jahan versus Union of India. The choice of a partner, whether within or outside the marriage, lies within the exclusive domain of each individual. Intimacies of marriage lie within the core zone of privacy, which is inviolable. Whom I select as a person to get married, whom I select as a person from a different religion, is not for the state to interfere with. That is my personal independent decision making. So I decide whom I want to get married. So in Shafin Jahan versus Union of India, the Supreme Court went on to say, if a person who is attained the age of majority, that is 18 and 21, if they have sound mind, they would be able to decide whom they would want to get married, irrespective of the caste, irrespective of the religion, and if the state interferes in that particular selection, it is a violation of the state. The state cannot enter into the domain where a person chooses a partner, said Shafin Jahan versus Union of India, with respect to the religion. And then we have Shakti Vahini versus Union of India. When two adults consensually choose each other as life partners, it is a manifestation of their choice which is recognized under Article 19 and 21 of the Constitution. The focus of this judgment was with respect to the Ka Panchayats. What was happening with the Ka Panchayats? The Ka Panchayats were acting as a kangaroo courts. What were these kangaroo courts? They decide whether this person should marry to another person of a specific caste or not. So it was not a legally mandated court, it was a kangaroo court. Everything was happening on the whims and fancies of few people who were acting as the Kaps in that particular panchayat. So they were the village heads as well. So this organization was deciding who should marry, who should not marry, and what is the caste hierarchy, so on and so forth. So in this particular judgment, the Supreme Court went on to say that caste groups or any other organization or these kangaroo courts have no legal mandate and they cannot interfere if a man and a woman want to get married. So this is their personal choice, said the Shakti Vahini versus the Union of India. And finally, in Navtej Johar versus Union of India, the Navtej ruling essentially said that LGBTQ community are equal citizens and underlined that there cannot be discrimination in law based on sexual orientation and gender. So these were the major arguments put forward when it comes to the same-sex marriage. So you need, whenever you speak about a particular case, one side the arguments are made, there is another side which also makes the arguments. That happens to be the respondent. The respondent in this particular case happens to be the Government of India. So what were the arguments that were put forward by the Government of India? The Government of India said that when it comes to the marriages has an imprint of the religion. So these are the personal laws which have to be governed. So the religious definitions of marriage exist. So it is the domain of the personal laws. Here the Supreme Court should not interfere. Why? Because there are customs, there are values, there are traditions, there are principles that are added when it comes to the marriage. So when it comes to the marriage, it will have a religious imprint on it. The state should not interfere, and at the same time, when it comes to the judiciary has no power whatsoever to involve in the religious affair. You can interfere in the secular affair, but you cannot interfere in the religious affair. So one of the major arguments made by the Union Government of India is with respect to, since this is the domain of the religions, the religion is important, and as a result the judiciary cannot step into the religious angle. Then the subsequent articles and the subsequent arguments will have to be read together. What are those? Petitioners, they say that the state cannot have no role in regulating the personal relationship. They also say that this is with respect to the right to privacy. So with respect to all these arguments, we have the government which said yes, privacy is very important. Yes, we accept what happens within the four walls, that is with respect to the privacy. But when it comes to the marriage as an institution, marriage will have to be accepted by the society. Marriage will require societal acceptance. When it is society which is accepting it, that is where the state can interfere. How the state can interfere? Let's say for example, you would want to get married. If you want to get married, let's say for example, this will require the social acceptance. What if the couple don't like each other? They would want to separate. That is when divorce laws comes into picture. Let's say the people have got married, then what they will have is the succession. So whom this particular property will get moved on to interstate and the will guarantees are all present in the matters of law, and that is where laws are present when we speak about bigamy, when we speak about polygamy, when we speak about divorce laws, when we speak about dowry harassment, when we speak about other kinds of harassment. We have the laws that are made. Since privacy is only within the four walls, that cannot become the norm of the social acceptance. If marriage has to be a social acceptance, the state can interfere and make laws with respect to the divorce, dowry, so on and so forth. So when it comes to the marriage, it is the exclusive domain of the parliament. It is the exclusive domain of the legislature. It is only they who would be able to make the laws, and it is not the domain of the judiciary to make the laws. When we have the Special Marriage Act, the Special Marriage Act only speaks about the heterosexual couples. So the Supreme Court or the judiciary cannot interpret heterosexual couples, that is the husband and the wife, as homosexual couples. When it comes to the homosexual couples, who will be the husband and who will be the wife? How can one person lay claim to the dowry? Who is asking for the dowry and who is giving the dowry? What are the kinds of violations that we see? In case there is any excess physical harm that is being done, who will be the husband, who will be the wife, what kind of laws? This cannot be and should not be interpreted by the judiciary. This is the realm of the parliament, this is the realm of the legislature, and in case the Supreme Court does enter into the realm of the legislature, what we seek is that power which is called as the judicial overreach, and this is not judicial wisdom, this is judicial overreach, said the government of India. So the government of India also laid judgments also took the judgments of the US Supreme Court, including the 2022 Dobbs versus Jackson case on the limits of the judicial review. In the Dobbs ruling, the Supreme Court held that abortion neither finds express mention in the US Constitution nor is deeply rooted in the nation's history and tradition, and therefore cannot be protected as a constitutional right. Yes, even if you want to make a law, it is only for the legislature and the parliament who would be able to make the law, and this is not the domain of the Supreme Court of India, said the union government. And when we look into world over, there are as many as 32 countries which have accepted same-sex marriage. For example, we have United States of America, we also have Brazil as well, we also have Norway as well. Taiwan, which happens to be the East Asian country, has also accepted the same-sex marriage. But the argument that we are trying to emphasize is, in all these countries where the same-sex marriage has been accepted, it is the law which has been passed, it is the power of the legislature, it is the power of the will which has been able to create and validate and authenticate the same-sex marriage, and only in about 10 countries it is because of the ruling of the judiciary. So when you look at a comparison and juxtapose it, what you have is 30 countries where valid law has been passed. It is only in 10 countries where judiciary has taken the precedent, and after the ruling of the judiciary, same-sex marriage has been accepted. This clearly depicts a picture that when it comes to the same-sex marriage and authenticity, it is the law, it is the parliament, it is the legislature who should be driving the narrative, and it is not the judiciary, said the respondents, which is the government of India. Taking a keen look into all these arguments made by the petitioners as well as by the respondents, we have a judgment made by the Supreme Court in the favor of 3:2. So what is a constitutional judgment or a constitutional making? When we speak about 5 judges sitting, that is whenever we speak about a constitutional mandate or the constitutional cases, this will require at least 5 judges sitting and introspecting and delving deep into that particular subject matter. So in this particular case, 3 judgments were in favor of the government, that is the respondents, who said yes, in case this same-sex marriage has to be accepted, it has to be accepted only via the law, only parliament has the power. So they said, and they were against the petitioners. And when we come to the minority judgment, which was given by CJI Chandrachud as well as Justice Cole, they went on to say that CJI in his opinion does not accept the center stand that the issue of same-sex marriage can only be dealt with the marriage and not by the Supreme Court. He says the doctrine of separation of powers cannot stand in the way of fundamental rights. Since this is more to do with the fundamental rights of the people, we have the right, said the Chief Justice. And then Justice Cole also joins CJI in battling for civil unions for non-heterosexual couples. He says legal recognition of the civil unions for non-heterosexual couple represents a step towards marriage equality. So he also said that we have to espouse and support the value of same-sex marriage. But they were in minority. The majority judgment said we do not particularly subscribe to the views of the CJI on democratic intimate spaces. These outcomes were brought by legislative acts, so it is only the laws and the parliament which should be able to do so, said the majority perspective. So the minority perspective was in favor of the petitioners, so they were in favor of the same-sex marriage. But then the majority viewpoint, that is 3 judges, said they may or may not be in favor of the same-sex marriage. But ultimately, if a law has to be brought into the law books and if Special Marriage Act has to be recognizing the homosexual couples, it is only the government, the legislature and ultimately the parliament which should be able to make the laws, said the Supreme Court of India. So the Supreme Court of India, in a landmark judgment with respect to the same-sex marriage, has said that legalizing same-sex marriage does not fall under the domain of the Supreme Court and the judiciary. It is for the legislature, the parliament to decide, said the Supreme Court of India. However, they have also given some recommendations as well. What are these recommendations? Ensure queer community is not discriminated against, so they should not be discriminated with respect to the heterosexual couples. Ensure there is no discrimination in access to the goods and services. In case they want to access goods or services, they should not be discriminated against the heterosexual couples. Sensitize the public about the queer rights. Give the public the awareness and bring them a new dimension and a knowledge and a wisdom towards communicating to the general public what are the rights of the queer community, the LGBT community. Create a hotline for the queer community. In case these people are under stress, it can be under the physical stress or it can be the psychological stress. It is where they should be able to communicate to one of the psychologists. So create a hotline, create a toll-free number so that they would be able to contact and communicate their issues and ultimately get their issues sorted. Create safe houses or garima griha for queer couples, and in case they feel that there is threat to their life, they should be safeguarded under the safe houses. Ensure intersex children are not forced to undergo operations, and no person shall be forced to undergo any hormonal therapy, said the Supreme Court of India, and added to it, in case there are protection that is sought by these homosexual couples, the police should not harass them, and at the same time what rights should be given to them. Appoint a committee, and this particular committee should be headed by the cabinet secretary. What rights should ultimately be given to the homosexual couples? For the same-sex marriage couples, they need not be accepted and they need not be recognized under the marriage column, but then what rights have to be given to these homosexual couples will have to be recognized by the government of India, and such rights should have to be given to the people. Is what is this judgment all about? It is this that we have to understand with respect to this topic. Now let's look into the next article. This article here is speaking about what is called as the red tide. What is this red tide? As you can see from the image, this is where the blue water is and this is where the red water is. So when algal bloom happens, when the growth of the algae increases considerably in a place, that is what is called as the algal bloom, or it is also called as red tide. Why is it called as red tide? That is because there is a change of the color of the water, which is why it is called as a red tide. So what is red tide? Sudden excess bloom or growth of the red algae or the algae in that particular region is what is called as red tide or red algal bloom. And when the color of the water changes to red, remember, that is what is called as red tide. And do note, when it comes to algae, different kinds of algae are present. We have the green algae, so on and so forth. So whatever, it is not just restricted to the red algae, you also have different kinds of algae as well. So when it comes to these algae, why exactly does it grow? That is because of excessive nutrients. When we speak about nutrients, what are the kinds of nutrients that we are speaking about? We are speaking about excess agricultural overflow. What is this agricultural excess overflow? When we speak about fertilizers, these fertilizers have excessive nutrients. We make use of NPS, that is, we make use of potassium, we also make use of urea, so on and so forth. When this excess chemicals that flows and seeps into the water, that creates excessive nutrients for these kind of algae. They start consuming it and there is excessive growth of the algae. So what are the environmental conditions that is required? Abundant light, high temperature, high pH level, stagnant water, excessive nutrients, and at the same time sources of excess nutrients are from agriculture. It can also be from the industry where there is chemical discharge and waste. It can also be because of the urban life in the form of sewage and waste runoff, and it can also be because of the climate change as well. Increases in the water and air temperature, increase in droughts and flooding, changes in salinity, increased amount of CO2, sea level rise, and coastal upswelling. These are some of the causes of what we see as called as the toxic algae bloom. So what is toxic algae bloom or harmful algae bloom? Is nothing but red tide in this particular case. Why are these red tides or the algal bloom dangerous? That is because when these this particular species outgrows. So there is more number of algae present in it. These algae are present in a particular area and these are consumed by the fishes. These are consumed by other species as well. So the minute they are consumed by this species, there is death, there is drop in the numbers, and many species after they consume, they start passing away, and then ultimately the number starts decreasing as well. So one of the major problems is when these species, that is the red algae, starts increasing, there are powerful toxins that are released by these algae, and when it is consumed by these species like fishes, they are killed and they pass away. That's the first major problem. And the second major problem is these fishes, in case they are alive, they do consume these toxins as well, and this ultimately enters the food web. These fishes are consumed by the human beings, and these human beings will also face health related problems, and as a result it would cause a greater damage to the economy. This would also cause a greater damage to the livelihood of the people. This will have a greater consequences on the oceanic tourism as well. So the economy is hit because it will have significant damages on the crustaceans as well as the fishes, and once these fishes consume, they may pass away, they are killed, and if these fishes are alive, it are consumed by the human beings, and this will result in health related problems to the human beings. And thirdly, the minute these human beings consume it, what you will have is health related problems, and as a result this catch is not taken by the human beings, and then this could hit the livelihood means of the fishermen are some of the issues. In order to overcome all these issues, instead of using the fertilizers in the agricultural sector, we can go with the organic use. We can stop using the chemical fertilizers as well as the pesticides. We can conduct mandatory septic tank inspection in case there is sewage and the waste runoff that is entering the oceanic water or the river water. That has to be prevented. So they have to be filtered and purified over the period of time. What we require is stronger water quality standards as well as the regulations, and at the same time, whenever we are inputting like in the agriculture, this has to take into picture the organic modules and the manures and not the fertilizers. These are some of the measures that we would be able to take with respect to the red tide. Now let's look into the next article. This article says ST status for the Meities is examined and rejected in 1982 and 2001. We have the Meitei community in the Manipur. All that they have been seeking for is the status of the ST community. First, we have to understand how is the ST status given to one of the communities. When we speak about the ST status, we have to go back to the year 1965. How is the ST status given to a particular tribe? That is where the criteria has been established by the Lokur committee. So the Lokur committee was the committee that was appointed in the 1965. They came up with a set of fixed criterion. If there is a particular community which is seeking for having the ST tag attached to them, in that case they should be able to meet all the criterions that have been established under the Lokur committee. So what are the indications and the parameters that have been laid in the Lokur committee? That they should have primitive types, they should have distinctive culture, they should have geographical isolation, shyness of contact with the community at large, and backwardness. This is the criteria that has been established by the Lokur committee. If they have been able to meet any of these criterion established by the Lokur committee, that is when a proposal will be made by the state government. So state government would be able to make a proposal, and after this proposal is made, it will go to the central government, and only the central government would be able to decide whether this particular tribe has to be given the scheduled tribe status or not. So the constitution allows only parliament to finalize the inclusion by passing the required amendments to the Constitution Scheduled Tribes Order of 1950. The state governments can only make the recommendation. It is ultimately the central government which will decide whether this tribe has to be given this status or not. What happened with respect to the Meitei community? The Meitei community, Two surveys were done, one in the year 1982, the other was in the year 2001. When this proposal was made whether the Meities will have to be given the scheduled tribe or not, back in the year 1982, we have the Registrar General of India which looked into it. It looked into it and said the Union and Manipur governments have not made this information public. Why? Because the scheduled tribe list has been examined and rejected twice over the last 4 decades according to the documents seen once in 1982 and the other in the year 2001 by the state government. What did they say? That they do not meet any of these criterion established by the local committee. Officials of the Tribal Affairs Ministry fished out the historical documents in this particular backdrop, and they felt since the local committee has established certain criterion, since these criterion are not being met by the Meitei community, and as a result we need not have to give permission for these tribes, that is the Meities, to be granted the scheduled tribes. As of now, they fall under the OBCs. Remember, when it comes to the other backward classes, what we have is the state government which would be able to recognize them as the other backward classes under the state list. But for the central list, you again have the Ministry of Social Affairs, Social Justice, which has to accept it, and in the state level, for the state level reservation, they would be able to give it under the state OBC list. So in the state, they would be able to give it under the state OBC list, but for SC or the ST, it is only the recommendation that they make to the central government, and only the central government becomes the authority to grant the SC or the ST list. But in this particular case, since the Meities are the OBCs in the state of Manipur, since they do not meet the established criterion as laid out by the local committee, since they also happen to be the dominant community, they were not given the status of ST as looked at in the 1982 as well as the 2001. Now let's look into the next article. This article says Kerala Mulls planting bamboo along Munnar's Cap Road to avert landslips. In the name of development, what are we doing? We are developing large scale infrastructure. So we are also developing roads as well, where we have huge mountains. So we have huge mountains. So within the mountains, what we require is the roads. But then when we have excessive rainfall or we have flood-like situations, these mountains will also see landslides as well. So in order to prevent the damages to the landslides, the Kerala government has come up with a proposal where they are planning to plant bamboo trees. So when these bamboo trees grow and they become 5 to 6 years old, they get deep into the water, they have deep roots, and as a result they would be able to prevent these landslides. So more analysis will be taken up once it is actually implemented. For now, what you can do is this can become the fodder for your mains answer writing. How do you prevent landslides? Give this example where the Kerala government is planning to come up and install these bamboo trees along the mountain areas, primarily because they feel that once the bamboo is matured enough at about 5 to 6 years, their roots become deep rooted and they would be able to prevent the landslides. So this can act as one of the pointers for your mains answer writing. Now let's look into the next article. This article says when tigers and jackals get the same protection. We have the Wildlife Protection Act. Under the Wildlife Protection Act, what we also have is different schedules. How many schedules do we have in the Wildlife Protection Act is what you have to put in the comment section. Under this, what we have is a Schedule 1. Schedule 1 happens to be one of the important schedules where major animals will be put and they will be protected, and it has high level of protection if it is put under Schedule 1. But this is where the author goes on to say, when you add too many animals or species into this Schedule 1, there will be no differentiation that will be made. What are the major concerns that are voiced by the author? The author says that as of now, there are more than 600 species which are added into the Schedule 1. So if you are adding more than 600 species into Schedule 1, how are you going to allocate the resources? What you have to do is take out a certain amount of money, funding, and invest on protection and conservation of these kind of species. If there are too many species in that particular list, how are you going to allocate the resources is the first major concern. Second major concern is with respect to the spotted deer or chital, which is placed in the Schedule 1. This happens to be one of the species which is not native or not endemic to the Andaman Islands, and as a result it causes significant harm to that particular region. When you place a particular species in Schedule 1, irrespective of which region that particular species belong to, one will not be able to kill that particular particular species because there is certain level of highest level of protection that is accorded to this particular species, and as a result what we have to do is provide protection to this particular species irrespective of the religion. But this particular species in Andaman is not native, it becomes an invasive species, and even if it becomes an invasive species, that particular regional forest department would not be able to kill it or cull it because it has been provided protection under Schedule 1. So regional specificities and regional boundaries and contours will have to be drawn, that all species whichever requires a uniform protection, for example tiger, elephant, so on and so forth, will be taken into consideration under Schedule 1. And even if you are placing under Schedule 1 some of the species, an exception and a provision should be given such a way that if it is in such and such region, they should be able to cull it or kill it based on the circumstances in case it becomes invasive or it is causing too much of harm to the vegetation in that particular region, says the author. The third that we have to take into picture is with respect to the rights of the farmers. Let's say for example we have the wild pig. The wild pig in certain pockets is creating a lot of ruckus. Why? Because it is destroying the crops and the livelihood means of the farmers, and as a result in few pockets at least an exception should be given. They should be taken out of the Schedule 1 and ultimately put into Schedule 2 so that they can be, or farmers' rights can also be safeguarded as well. The third issue is, despite the support of many individuals in the forest bureaucracy, the paperwork involved in getting permits for research is tedious and time consuming. What do we understand by it? Let's say for example this is Schedule 1 animal. Let's say tiger. Tiger happens to be a Schedule 1 animal. Let's say I have to conduct some research on tiger. I have been given permission under Schedule 1, an exception has been given late where in case I want to conduct a scientific analysis or research and development, I would be given permission to conduct that research. But if I have to get the permission, there is lot of permissions that I have to take. It is a tedious process. They procrastinate a lot. There is undue delay that is called for, and as a result, even for a person who is motivated to conduct a research and analysis and development and understand what is the root cause analysis of a particular issue, he would not be able to do, and he would be discouraged to do, primarily because this person does not want to go through this large undue delay that has been taken care. So this process will also have to be expedited, says the author. So primarily the author says we have the Wildlife Protection Act. Under this we have the Schedule 1. More species are included into it. So let's have a selective approach. Only those which are very critical should be added into it. In case they are not native to that particular species, culling or killing them should be given permission to the forest department on the basis of terms and conditions, and at the same time this license permit raj that is given for the research should be reduced and they should be given faster approaches so they can conduct their research. What is this article all about? It is this that we have to understand with respect to this article. So this is it for today. In case you are liking these initiatives, please do like, subscribe to our YouTube channel and share it with your fellow aspirants as well. So this is it for today. Thank you for watching. All the best.